Good evening, I'm Courtney Jerome. Welcome to Ask the Specialists. Tonight we ask the estate planners right here on CMU Public Television. Thank you so much for joining us tonight on Ask the Estate Planners. Our real conversation tonight is all because of you, so we're welcoming you to give us a call or send us a question via social media all about estate planning. So if you have a question about wills, about trusts, powers of attorney, this is the show for you. We're going to have a phone number at the bottom of our screen as well as our social media handles. So that number is 1-844-975-3343, and as you see, we have phone operators standing by ready to take your calls. And you can also submit your questions via our Facebook page, facebook.com/askthespecialists, or via Twitter. Our handle is @WCMU_AskThe. Now, when you submit your questions tonight, they are going to be answered by our live in-studio guests. So I'd like to take that opportunity to introduce the two of them to you. Thank you both so much for being here tonight. We greatly appreciate it.
Yes, thank you.
So we have Doug Chelgian from Chelgian and Tripla offices. Can you please tell us a little bit about your offices and what kind of services you provide for people?
Well, our firm is just an estate planning and elder law firm. So we do estate planning and we do planning with aging issues, and that would include protecting vulnerable adults, qualifying for government benefits and those types of things, as well as wills and trusts. We have offices in Midland, Jackson, Battle Creek, East Lansing, and Ithaca.
Okay, excellent. Thank you. And then sitting next to you, we have Randy Dickinson. Thank you for being here as well.
Yeah, thank you.
And then you are with Isabella Bank, which you have quite a few locations throughout our state as well.
Yes, correct. I'm a vice president and trust officer with Isabella Bank, and Isabella Bank is headquartered in Mount Pleasant, Michigan, but we have 27 branches within about a 1-hour radius of the Mount Pleasant area. And the bank size is about $1.5 billion, so the bank is a very large bank in the state of Michigan. As far as myself individually, personally, again, I work in the trust services area, and half my business is dealing with investment management. People or foundations want us to manage investments for them, so we can do that. The other half has to do with trust and estate administration. So that's where somebody may name Isabella Bank to come in, handle their estate, handle their trust, administer it in accordance with their wishes. So that's what I get involved with, and I look forward to answering any questions that people may have regarding that.
Okay, perfect. So as Randy just mentioned, they are ready to answer any of your questions about estate planning tonight. You already hear our phones ringing, so I know a few calls are coming in. But as those continue to come in, let's just start talking about a few really basic estate planning questions. Doug, how about we talk about wills? What is a will? What does it do?
A will is kind of the most fundamental tool for passing assets at death. So it's a relatively simple document as compared to, for instance, a trust. It only becomes effective on your death, and it accomplishes at least two things. One is, who's in charge? Who is my executor, or as Michigan calls, personal representative of the estate, and where does my stuff go? How do I want it split up? Who gets it? Who doesn't?
So it's nice and simple.
A will is part of typically part of a simple estate plan. Now, if you have a trust, you have a will too, but if you're of a will-based estate plan, that tends to be the most simple estate plan.
How important is one?
I'm a lawyer. I think it's a really good idea. How important relative to what? Relative to powers of attorney? Sometimes I would tell people a power of attorney, depending on your stage of life, may be more important because it provides other forms of protection that maybe a 40-year-old is more likely to face than a will would.
Okay, and then Randy, you specialize in trusts.
Yeah, so what happens is the bank, we do not have any attorneys on staff. So Doug and other attorneys will draft the estate planning documents. And that might be a will, power of attorney, healthcare power of attorney, might be a trust. So the attorneys will draft those documents, and Isabella Bank may be named as the the company that is going to handle the estate. So we would step in, and we could be the successor trustee. So the individual might be the initial trustee. Isabella Bank, upon their incapacity or death, could step in and become the successor trustee.
Okay. Okay,
Yeah.
excellent. So what happens if a person passes and they do not have a will or a trust set up? Maybe just to explain really the importance of these documents in your estate planning process.
You asking me?
Sure.
Okay. That's called intestacy. Well, and I guess, you know, first of all, you could have beneficiary designations on a life insurance policy, or even transfer on death arrangements on an account that would provide for the assets to pass at death, and the will or the trust wouldn't implicate that. But if you just had an asset in your name and you died, then Michigan law of intestacy would step in and make some assumptions about who you would presumably want it to go to. If you have a wife, husband, probably to that person. If you have children, maybe to your children in equal shares. If you have a wife or a spouse who's not the parent of your children, then there's a formula for how it's divided between them. So there's a lot of law that sort of attempts to replicate what the state would assume if you don't make those expressions yourself. And likewise, the law would create assumptions about who you would want to be in charge. Well, if you have a spouse, you probably want your spouse to be the executor. If you don't, then your children would have priority to serve.
Okay. And we have a caller from Boyne City who has a question that I think flows really well into this nice and basic summary of what a will and what a trust can do. Why is it recommended to have both a will and a trust?
Well, first of all, as Doug alluded to, if you die, if you pass away and you have something in your own name, so you own it in your own name, it's going to be probated. If there's no beneficiaries or joint ownership, it's going to be probated, and your will is going to govern what happens to that asset. The ideal situation is when you have a trust, you're going to transfer those assets so they're retitled in the name of your trust, so that when you die or you pass away, you don't own any assets in your own name. Everything's owned in your trust. So the ideal situation, if you have a trust, is your will not come into play. But your will is the catch-all, just in case you did forget to fund your trust during your lifetime. The will, it'll go through the probate process, it'll end up in your trust. So they call it a pour-over will. It basically is going to pour over into your trust if you do not fund your trust during your lifetime. It's a catch-all.
Okay, excellent. Well, we are already receiving some really great questions from you, the viewer, this evening. So thank you, and please keep them coming. The phone number is at the bottom of your screen, as well as ways to contact us via social media. We have a viewer from Drummond Island who is asking, is it legal to change the name of a power of attorney and on a will as well?
I don't understand. Is it legal to change the name on a power of attorney? Mm-hmm. Well, it's legal. It's legal for the person who creates the power of attorney to create a new power of attorney and replace an old one.
Okay. How about for a will? Can they change
It's
change
certainly
the name on
anybody can change their documents as long as they're competent. As long as I'm competent, I can say, well, you know, Sandy didn't come over to Thanksgiving dinner. I'm doing a new will. I'm leaving it all to Joey.
Okay, great. Now, this viewer is from Southfield, and they have a few estate tax questions. The first one is, does the state of Michigan have estate tax, and what are those limits?
The state of Michigan does not have, well, they had at one time years ago an inheritance tax. The state of Michigan does not have an inheritance tax. The federal government has an estate tax. Okay, so if your estate is greater than, in 2015, it's $5,430,000. If your estate is greater than $5,430,000, you could be subject to an estate tax.
Okay.
So,
okay, you just
lucky
answered
the person
their second
that,
question,
yes, lucky
too.
the person that is in that situation.
Okay, great. And their third question then is there a federal form for after death of a person that someone would need to fill out?
No, upon death, again, what would happen is the personal representative, the trustee, would file their final income tax return. But if they fall below the federal state tax limits, you would not necessarily have to file any type of forms with the IRS.
Okay. Another caller, this time from Crest Hill County, they were wondering your recommendations about a joint deed on 100 acres of land.
Well, that would depend on who it's joint with. Generally, joint ownership is not the ideal way of accomplishing estate planning objectives. If it's joint with somebody who gets sued for running over the neighbor's dog, you'll be sorry you put them on it. If you want to leave it to somebody, then leave it to somebody through your estate. And actually that raises an important question, because recently Michigan law has changed to allow real estate that passes, residential property that passes through a probate estate or through a trust to avoid uncapping for property tax purposes. So really there's benefits to, there's no harm to keeping it in your estate, and keeping it in your estate also accomplishes some beneficial capital gains tax consequences that you'd want to consider. So generally, your estate plan is the expression of your wishes. Joint ownership is a typically less than ideal way of accomplishing that.
Okay. Okay, and Randy, here's another one of kind of joint, but these are with co-trustees. A question from Lake Orion. If there are co-trustees and one trustee is also the personal representative, what is the position or duty of the trustee who is the personal representative, and what else of both trustees?
Okay, so you're wearing two different hats then. If you're the personal representative, you could be the personal representative of the will, and you'll be responsible for those assets that are going through probate. Okay, so the personal representative will take care of administering the will in accordance with the probate process. Those assets then, if they were to move into the trust, now you put on your trust hat, and you're going to be acting as co-trustee with the other person. So in one instance, you're acting as a personal representative if you're the only individual, and then you could act as co-trustee with the other person. And then the two of you then are going to be responsible for following the wishes of the grantor and fulfilling the terms of the trust.
Okay, so very specific duties.
Very specific duties, definitely. Yes.
Okay. Doug, how about this question for you? Our viewer from Lewiston, her mother and father drew up a will that when they pass, the children will get a payment each month. Now, it looks like her mother did not want to sign that will. So the question is, if the father dies first, can her mother cancel the will altogether?
Well, a will is an individual document. So if dad dies and it all goes to mom, then it's mom's will that's going to control, and if mom's competent, she can change it at any time. But if she hasn't signed the document to begin with, then it's not a valid document. So I'm not sure what the status would be if she has, well, if she has no will that's signed, then her estate would be, like we talked earlier, an intestate estate.
Okay. And here we have another will question, this time from Beaverton. Is there a way to avoid probate using a will?
What happens is, again, sometimes people have an understanding that I have a will, so I avoid probate. And that's not the case. You have the will because you're directing how you want the probate process to go. Who do you want to be the personal representative to handle your estate? You'll name that in your will. Who are going to be the beneficiaries in the will? So the will is the guidelines for as far as how the process is going to take place. So you cannot avoid probate by having a will, if that was the question.
That was the question.
Yep.
Okay. Okay. We are receiving a lot of great questions tonight from our 844 number and social media channels, so please keep them coming. We have a couple more here about trusts. How do you fund your trust, is asking a viewer from Lapeer.
Different assets are funded differently. Many assets can simply be titled in the trust. You can deed your house, you can deed your farm to the trustee of your trust, who may be you at the time you create it. You can retitle your investments or your bank accounts and your CDs into the name of the trustee. Other assets, particularly retirement accounts, are going to be funded to the trust through beneficiary designations. Likewise, life insurance is typically going to be funded through the trust by naming the trustee as the beneficiary. So, and as Randy mentioned earlier, that's sort of a, if you're going to go to the trouble of creating a trust, you want to make sure that you have taken those steps to make sure that the assets that you have are either owned by the trust or will be paid to the trust at your death.
Yeah.
Okay.
And Courtney, I think Doug and I, what we see a lot of is people that either have drafted a will or drafted a trust. They have this estate plan, but the assets that they own, either life insurance or investment accounts or bank accounts or real estate, they're not titled properly to flow with their estate plan. So there's two parts of it, having your estate plan in place, and if it's a trust, making sure that you have those assets properly titled in the name of your trust. And many times they forget to do something when it comes to that.
Okay, this flows right into our very next question from Mount Pleasant. If you have a trust, is it important for you to put your home, which you live in, into that trust? So that's the real estate asset that you were speaking of.
Right. What you have to do is look at each one of your assets, whether it's a retirement account, life insurance, real estate, what have you, and you have to make a determination what is going to happen to that. In most instances, if you have a trust, you're going to fund the trust with your assets, including your home.
Okay, great. Now Doug, a couple questions ago, you were talking specifically about beneficiaries, and we have a caller from Sheboygan who's asking if a single parent is a widow and receiving benefits from a deceased spouse's pension, can the children be named beneficiaries?
Of a pension?
Yes.
Typically, a pension is only going to pay to the surviving spouse. It would be highly unusual for a pension to continue to pay for the children.
Okay. Okay. And then this question, do I file income taxes if I'm receiving workman's comp and extended disability from my job and also Social Security disability income? So it's more of a tax-related question. That
Really
we
not
have
an
here.
estate planning question at all.
Not an estate planning question.
I can't.
I would
do not
talk
know
to your
the-
CPA about
Right.
that.
Okay.
I suspect you probably might want to file your taxes.
Okay, excellent. And so we will have an Ask the CPAs coming up later in the season. So please take a look at our website, wcmu.org, for our full schedule here coming up for the next few months as well. Let's see here. We have another question coming in from the Traverse City area. She is past 59 and a half years old, and she was asking if she can put into a Roth 401k through, or she does put into a Roth 401k through work, and she's currently putting into a traditional 401k. So at 59 and a half, can she pull out of the 401k? And should all of her short and long-term savings go into the Roth to make it a liquid savings account? Or should she continue to invest in the traditional 401k? Now, there are a lot of details in that
There
question.
are a lot of details. And you know, when it comes to whether or not you should be making a Roth IRA contribution or a traditional 401k contribution, it starts with your tax bracket to begin with. Are you in a higher tax bracket? Are you in a lower tax bracket? What makes the most sense as far as contributing to a Roth or a traditional? And then, again, depending on her situation, normally the longer you can keep assets in a Roth, which grow tax-free and tax-deferred, and there's no requirement to take the money out, it would be better to have in that type of vehicle. So I don't know, Doug, I'm not sure exactly
It's hard to
the
speculate.
entire question, but,
Right.
but you really just need to sit down with an advisor, financial advisor, and explain the entire situation. And certainly somebody can give you guidance on what would make the most sense and the reasons for it, too.
Right, especially if they have access to some more information.
It certainly helps.
Okay, this caller is from Alpena. He had a trust. His brother disposed of that trust. How can he get that back, or even can he get it back? It was in her name, and it looks like she ruined his credit.
I don't know about the ruining his credit part, but if somebody loses their trust, is that what you're saying? I gave my brother my original estate plan, and he disposed of it. I would contact the lawyer who did it and see if they still have a copy of something, or simply create a new restated trust agreement that updates the document and captures whatever assets are currently titled in that. So go to a lawyer and get it redone if you've lost it.
Okay, okay. This viewer from Traverse City asks, if one grantor of a trust passes away and only one grantor is living, what is the responsibility of the successor trustees upon second grantor's death?
So it sounds as if they have a joint trust, and there's two grantors. The two of them created this joint trust. One of the grantors passed away, and the trustee, which may be the same as the grantor now, the surviving grantor, the trustee is basically managing it. So the grantors, the two of them, would have decided exactly what is to happen to that trust upon the death of the second to die. And so whoever the successor trustee is, they just need to make sure that they're following the wishes of whatever the grantors, following the wishes of the grantor. So, Courtney, I would say there is that they just need to make sure they have the right successor trustee, that the successor trustee is familiar with the wishes of the grantor, and the successor trustee is familiar with the document, that they can properly follow their wishes.
Okay, great advice, thank you. Another viewer from Fenton is asking, her mother's house and possessions were deeded to her. Will that suffice, or will she find herself in probate?
Well, if it's an outright deed, and mom transferred the house to her, you can't deed the personal property, but if she deeded the house to her, then it's her house. And no, that you don't have any, to probate anything. In fact, if it was done, if it was actually deeded to her, then she owns the house now.
Okay, okay. And here's another question about assets, this time from Sterling Heights. Can you put an IRA or a 401k in a trust?
What you can do is you can name your IRA or 401k the beneficiary. The trust can be the beneficiary, but an individual has to be the owner of an IRA or a 401k.
Okay.
Okay, so,
Okay.
and if you're going to name the trust as the beneficiary of an IRA or a 401k, which you can, but sometimes there's some reasons that you would want to name the trust, and there's some reasons that you may want to name some individuals, there's some tax reasons for it. So you have to, you certainly can name the trust as a beneficiary, and in many cases you will, but you want to know the pros and cons of different alternatives.
Okay. Now, does someone need to add a beneficiary to a will if they are joint on a checking account? This question is coming from St. Clair County.
Well, I think what they're getting to, because this comes up a lot, is people will make somebody join on their account, and they'll do it because we call it a convenience account, so that their daughter can pay their bills. But then when mom dies, the property, because daughter was joined on it, becomes the property of the daughter. And unless the will specifically says the joint account with my daughter was set up for convenience and isn't intended to pass to her at my death, but is intended to be part of my estate, that would be a reason to express that in your document, because that argument over whether a joint owner is entitled to keep the proceeds of a joint asset or whether that was intended to be included in the estate and divided among the beneficiaries is a common source of family battles.
Yes, yeah, right. Did you want them to actually receive it as a joint asset, or were they only on there for the purpose of writing checks?
Okay.
Okay. And it's good for the personal representative or whoever's going to handle your estate to know that up front.
Okay.
Because afterwards, they're going to ask the survivor, and that person's going to say, no, I was on there for, she wanted me to have the money, possibly.
It goes on.
Yeah.
Okay, well, we have a handful of more questions to get to, and we only have a few more minutes left in our show. So we're going to try and get to as many of your questions as we can. But those that we can't get to within the live program, we welcome you to take a look at our Facebook page tomorrow, facebook.com/askthespecialists for your answers to those questions. So these next couple ones are about trusts. This one from Davison. If you have life insurance or a retirement plan and the beneficiary isn't the trust, then what happens? What is the benefit of putting them into the trust versus naming the spouse?
Well, as far as the life insurance, there shouldn't be an advantage one way or the other. The life insurance could be part of the trust, and if she is the successor, if she's the beneficiary of the trust or the successor trustee, however it is, it would just flow to the trust and she would have full access to it. The reason that you'd want to name the trust as a beneficiary of that, if something happens to the two of you and you name your spouse, she may not be living if something were to happen to you at the same time. So your trust will always be there. So there's certainly a reason for life insurance just to name the trust. When you get into retirement accounts, there may be some advantage to naming the spouse possibly as the primary, the trust as the contingent, because the spouse can certainly roll that particular retirement account into her own type of retirement account, be it an IRA of some type. So for retirement accounts, when you're talking tax deferred assets, there can be an advantage to naming the spouse first, trust second.
Okay. Okay. We have one of those trust and spouse questions, another one here. It might be our last one that we get to tonight. We'll see. Caller from Leroy. Her husband died 4 years ago. They had a trust made out. She's perfectly healthy, but she's wondering if something were to happen, or if maybe she goes into a nursing home, how would that affect the trust fund? Should she get nursing home insurance?
A trust that most people create, a simple trust, a revocable trust, doesn't, quote, protect assets from any creditor. So sometimes people have the misperception that I created a trust and now if I go to a nursing home, it won't be considered an asset and I can qualify for benefits, or if I get sued, they won't be able to get that. That's not the case. Trusts, a simple trust, revocable trusts, are not designed to accomplish those things. If she's healthy enough to get long-term care insurance and can afford that, that's always a good thing to explore, because the costs of care are expensive, and having insurance is a good way to provide for care options in the future.
Okay, excellent. Thank you very much. I'm afraid this is all the time that we have
very much.
Tonight. So thank you both, Doug Chelgian from Chelgian and Tripp Law Offices, and Randy Dickinson from Isabella Bank. We really appreciate you both being here tonight.
Yeah, thank you, Courtney.
Thank
and
you.
Of course, thank you to you for tuning in and for submitting your questions tonight. Please head over to facebook.com/askthespecialist for answers to the questions that we couldn't get to tonight. Those questions that you were asking when you called our 844 number were answered by these fine folks. So we'd like to thank Sean and thank Christine and thank Kelsey for being here and volunteering their time tonight. So that concludes our show. We hope that you can join us next week for an all-new Ask the Job Specialists. I'm Courtney Jerome. Have a good night.